Hi, it's Mike from Cashion Legal, and today I'm going to deal with a recent court decision which deals with a significant shift in Alberta employment law, specifically as it relates to how we calculate pay in lieu of notice. At the end of this video, I'll tell you how you might be impacted by this change, regardless of whether you're an employee or an employer. Let's start with the context. It is generally accepted that the maximum amount that an employee can be entitled to for pay in lieu of notice in Alberta is 24 months. In fact, there are prior court decisions that refer to 24 months as the rough upper limit or the upper end of the range. Because of this general understanding, employees and employers in Alberta often approach severance negotiations on the basis that the employee can reasonably request up to 24 months of pay in lieu of notice. For example, if you were dealing with a senior level executive who'd been with an employer for 20 years and was towards the end of their career, most employment lawyers would agree that that person could reasonably request up to 24 months of pay in lieu of notice, but no more than that. However, the recent decision in Lischuk and K-Jay Electric Ltd breaks that upper limit. In reaching this decision, the court relied on a body of cases from Ontario that speaks to the existence of exceptional circumstances, making the rough upper limit of 24 months inadequate in those cases. The court noted that a finding of exceptional circumstances normally arises where an employee has been with an employer for their entire career, rises through the ranks to a senior level position, and is terminated as they approach retirement age. These exceptional circumstances make it difficult for these employees to find alternate comparable employment, which is the ultimate purpose of providing employees with notice. The court in Lischuk noted that all of these factors were present in this particular case. The employee started working for the employer in his early 20s, and his employment was terminated when he was in his late 50s. He started his career in a labor position and had worked his way up to a senior management role. Additionally, the employee had limited education, and because of the specialization of his role, the court found that he really could only obtain employment with 2 other companies. Based on these factors, the court found the existence of exceptional circumstances and awarded the employee 26 months of pay in lieu of notice. It is my understanding that this is the highest amount of common law notice that an employee has ever received in Alberta in a reported decision, and the court confirmed that it was not aware of any other case where an employee had received more than 24 months of pay in lieu of notice. However, if you're watching this video and you're aware of circumstances where an employee received more than 24 months of pay in lieu of notice, please share a link to that decision in the comment section to this video, and I will purchase you a gift card to a Calgary-based business. So how does this decision affect you if you're an employee? Well, if you have been employed with your employer for a long period of time, you started in a low-level position and worked your way up to senior management, and your employer has terminated your employment as you're approaching a retirement, you may now reasonably request more than 24 months of pay in lieu of notice. If you find yourself in this situation, contact our office today. There is a link to our website in the description to this video. How does this case affect you if you're an employer? My recommendation following this case is the same recommendation I give employers anytime reasonable notice comes up. Make sure that you have an employment contract that deals with the employee's entitlement to pay in lieu of notice. In Alberta, you are permitted to include contractual language that limits the employee's entitlement to pay in lieu of notice to the mandatory minimums under the Alberta Employment Standards Code. Alternatively, if you're looking to incentivize employees to join your organization, you can include a contractual severance clause. The important thing is that a well-drafted termination clause can minimize the chances for dispute between you and your employee on termination of employment about what their entitlements are. If you're an employer and you need your termination clause reviewed, or if you need a written employment contract to start with, contact our office today because we can assist you with this. Well, thank you for watching this video. Again, I'm Mike from Cashion Legal. We're an employment law firm based in Calgary, Alberta, and we assist employees and employers with a variety of employment law issues. If you need any type of employment law assistance, do not hesitate to contact our office today.